regarding the topic per se. So Sebastião, you have the floor.
Thank you very much, Diogo, and happy to see familiar faces and names in the list of attendees. It's a pleasure to talk to a Portuguese audience on the topic, of course, coming from Portugal. And I will spare you, I hope we're talking all among privacy professionals here, so I'll try to spare you the long history that led us here. I think we all know how we got here, right? The fact that the old data protection directive has the similar mechanism, legal mechanism for transferring personal data abroad as the GDPR. So we have an adequacy decision regarding the US from the year 2000, which was annulled in 2015 by the CJU in the Shrems I case. Then we had the Privacy Shield that replaced the annulled initial decision, the Safe Harbour decision, that was then annulled again in the Shrems II case, which forced then the European Commission to enter into negotiations with the US authorities to enact a third adequacy decision regarding the US, this time entailing changes to US law that we will analyze now. So the question is, and rightly so, that we'll try to answer in the webinar, or at least raise further questions on it, was an adequacy decision as it was framed in the draft that the Commission published in December, sustain the scrutiny of the Court of Justice this time around? So is the third time the charm, or the efforts were no good in the end? So the context is, of course, the draft adequacy decision that the Commission published in December, based on the commitments that the US President and the US authorities assumed in the executive order last year, limiting the powers of the intelligence community in the US to access data for national security purposes, the EU citizen data, of course, and the creation of redress mechanisms together with those limitations. So before this draft adequacy decision turns into a binding and enforceable adequacy decision under the GDPR, we first need to see an opinion from the European Data Protection Board, so the collegial body of data protection authorities of the European Union, also a scrutiny by the European Parliament in a debate in the plenary, and it also needs a positive vote from EU member states at the Article 93 committee, Article 93 of the GDPR, and only then the Commission can approve a final text of the adequacy decision. So if we look at the draft, what are the novelties of the text when compared with the Privacy Shield that was, of course, invalidated by the Court of Justice? So there are no big news regarding the commercial principles that companies who self-subscribe to the framework need to comply with. They are apparently weaker in some respects than the GDPR, for instance, when it comes to data subjects' rights, because they have some wide exceptions to individuals' rights. And so some organizations that are planning on challenging the adequacy decision already when it's adopted have said that this could be a point of contention should it reach the CJEU once more. On the other hand, EU data protection authorities are more involved in the enforcement of the commercial principles because they can receive complaints from individuals and refer any matters to the competent US authorities, who can then enforce against US companies. They will also be organized in an informal panel to provide information and advice to the US authorities on how to remedy issues and advice on complaints received from individuals. But the most important part, I would say, is the assessment of the adequacy decision of the novel limitations and safeguards that apply to the collection of intelligence by US authorities in the United States. So the executive order and the adequacy decision refers to this, says that access by the intelligence community to data for national security purposes needs to be necessary and proportionate to protect a closed list of national security validated purposes. So this is quite important. And besides, EU individuals will have the possibility to obtain independent and impartial redress through a number of mechanisms, including through a newly created Data Protection Review Court, which we will analyze as well. So on the limitation to the access by national security agencies, we know that the executive order on the US side gives a maximum of 1 year to the intelligence community, so the different authorities, to update their existing policies and procedures to bring them in line with the executive order's requirements. And it is clear that the Commission hopes that this reform of the practices and the rules within the agencies will take place before the adequacy decision is final. So this is clear from the adequacy decision, but we don't really know if the adoption of the adequacy decision is conditional upon those reforms being implemented by US authorities. It is also true that the executive order limits the collection of data by intelligence agencies in the US to targeted collection when we're talking about data that is hosted in the US, so data that is transferred in the end under the mechanism, the adequacy decision. So bulk collection may only apply to data collected abroad. So when the United States collects data that is held abroad and not in the United States, which is also a positive development. On the other hand, in terms of redress, data subjects in the EU under the executive order and the regulations, implementing regulations by the US Department of Justice, can access the redress mechanisms by complaining to supervisory authorities in the EU, in this case, not DPAs, but the supervisory authorities of intelligence agencies in their own member states. So there's a difference there because individuals normally don't know so well who these authorities are in the end. And individuals will have their complaints investigated initially by the Civil Liberties, Privacy and Transparency Officer of the Office of Director of the National Intelligence in the United States, who determines whether a violation of applicable US law has occurred and determines appropriate remediation in case it has, and this decision has binding power on the agencies concerned, which was one of the criticisms that was made with regards to redress mechanisms under the privacy shield. So this is also an improvement in my view. When the CLPO, this officer that I mentioned, reaches a decision, it informs individuals that the matter did not consist in an infringement or that the infringement was dealt with appropriate remediation, not giving any further details about what happened. So this is sort of a black box situation in which the individual doesn't really know what happened there. But in the end, this is not much different from other recourse mechanisms that individuals have against surveillance practices in the EU, for instance, in France. So maybe there is not an issue there if we look at member state practices in the EU as well. In any case, individuals can appeal the decision of this officer to this Data Protection Review Court, either directly or via their national authority. In this case, there is a special advocate that is selected to represent their interests before the Data Protection Review Court. And the European Commission, the draft of the decision says that this court is an independent tribunal established by the Attorney General according to US Supreme Court jurisprudence, who can then impose appropriate remediation. And so it is argued that it would constitute a tribunal in the sense of the EU Charter of Fundamental Rights, so Article 47, and so it would pass the scrutiny of the Court of Justice in this regard as well. So this is the argument. Of course, we don't have a final text of the decision, and now we should ask ourselves the question: are these changes in U.S. law, as commended or validated in the draft adequacy decision, enough to satisfy the Court of Justice? Should it be called upon to decide on the lawfulness of the new adequacy decision? Of course, the draft of the EDPB opinion is imminent. We know that the EDPB discussed it in the last plenary in January. It is discussing a follow-up now in the plenary that is happening today and tomorrow. We don't know, of course, when the opinion will be published, but normally the EDPB opinion is a good predictor of the reservations that the Court of Justice may express. And so it is important to keep a close eye on what the DPP will say regarding the lawfulness of the adequacy decision under the Charter. DPAs actually seem to be more optimistic about the lawfulness of the scheme this time around. The DPS, so Wojciech Wiewiórowski, very recently said in an interview that the changes in US law that were enacted are something new and very promising. So there may be light at the end of the tunnel. But there are organizations who don't look at the situation so brightly. So we know that NEUB, an organization in Austria, which is led by Max Schrems, so the person who gave the name to the two Court of Justice rulings that led us here, they have expressed their own reservations, stating that the necessity and proportionality references in the executive order are mere lip service to satisfy EU officials. And they point to existing intelligence programs in the US based on intelligence laws like FISA 702, which remain in force. So this is a concern for them. And they also have the Data Protection Review Court that we touched upon is not a court in the meaning of the Charter, as it does not have proper independence from the US executive. So this is one, these are the two big reservations that they express. Also given the precedents that were set by the Court of Justice. What is, I think, is for sure is that the matter is unlikely to end up in the laps of Court of Justice judges anytime soon. This is because, despite the fact that NEUB announced that it would seek a direct avenue to seek the annulment of the Commission adequacy decision, that avenue doesn't seem to exist under the treaties of the European Union. If you look at the General Court of the European Union decision and an action brought by WhatsApp against the binding decision from the EDPB, and this is December 7, the decision of the court says that the company was not directly concerned by the binding decision, and so it could not bring an action for annulment against the binding decision by the EDPB. And this confirms the CJU's long-standing narrow reading of direct and individual concern that is required by the treaties to bring an action for annulment. And this means that likely NEUB or other organization that would be interested in filing suit against the adequacy decision will likely need to go down the long and the winding road of complaining to the DPA or filing an action in courts, then hoping that the National Court would, eventually ask preliminary questions to the Court of Justice on the validity of the new adequacy decision. And this is not sure that it's going to happen. It's likely that it's going to happen, but it's still not sure. And in the meantime, we still have the legal uncertainty that comes with not having an adequacy decision in regards to the US. We see companies and other organizations relying on alternative transfer mechanisms such as SCCs. I'm not going to touch too much on those because those are practical implications, which I'm sure Odia will cover better than me, although I can add some enforcement precedents and some use cases that I've seen over the past few months. But as per my initial intervention, I would like to close here, and I'm looking forward to the questions and the discussion.
Thank you very much, Sebastião, for this fantastic contextualization of what has been a very rocky road, and that seems to point towards continuing to be a very rocky road. And thank you so much for bridging to Odia's intervention by mentioning the more practical aspects that you are sure there are to be touched upon. And without further ado, Odia, you have the stage.
So the unexpected part is I'm going to repeat all of that quickly in Portuguese, right? So that's what I'm going to do. No, I'm not. Okay, so the one thing that I can say is that I invite you all. I unlike Sebastião, I don't know you all, but I'm happy that you're here, and I welcome you to connect with me on LinkedIn. I publish a lot of this type of practical takeaways on these, including actually an analysis of the draft adequacy decision and sort of the practical implications. So feel free to find me there. I want to do maybe a short kind of introduction, and then we can kind of dig into specific questions. My perspective on this and sort of the way that I've looked at it and written about it is I have a hashtag, which is hashtag cry and pray, which is basically what I think the only things that companies are able to do in view of this situation, right? Because basically the way that the case, the ruling of the case, both generally, but let's be honest, right? Mostly with respect to the US, it's a decision specifically with respect to the US, and the key big providers are located in the US. So in view of this decision, you basically have a decision that says, look, the NSA is watching, and the only way, and forget even Keneal actually had a decision where they said, forget the legal analysis in your TIA. Forget the part where you analyze the law. We already know the law doesn't work. Just move forward to the supplemental measures that lock out the FTC from getting access to your data, because if you don't do that, it doesn't matter. And we have a bunch of decisions also that say, the contract, because there are, separate types of supplemental measures that the EDPB cited in the decision. And some of them are contractual, right? Obligating the controller, obligating the processor downstream to do certain things, to inform the individual, et cetera. And there are decisions by DPA saying, who cares about the contract when if the processor is subject to US law, which they are, they have to comply with US law when they get a national security letter. They have to comply with the request. Therefore, the access is going to happen. The access, see above, is not compliant with EU law. Boom, the end. Okay. And that is, and in a lot of cases, this particular structure of putting in place technical measures, because they are just technical measures that would help, that essentially lock out the NSA completely, is not possible. It's not possible because you don't have a good alternative. It's not possible because the good alternative is expensive. It's not possible because you have to change your entire business model, right? And so then you're stuck. And you as a company, either a European controller that seeks to engage the services of a US company, or as a US company that wants the business, both of you are stuck, because you can, you can write your senator and, hope, but it's not going to make the law happen. So I think one sort of the premise of this is that this is a really difficult situation for companies. It's a very difficult situation for companies, situation which really can only be rectified by this type of agreement between the US and Europe, right? So now we have the draft adequacy decision, which I call the draft adequacy decision. And we're waiting to see what happens. And in this situation, I think we're going to dig into the question, so I won't reveal, I won't do it spoilers, right? But there's basically two parts to it, right? There's the national security NSA ate my cookies part, and then there are the commercial principles. The first part is a part where the US made changes. That at least everybody is on the same page with, right? They made changes. You can even say they made significant changes. I'm not sure if Max Schrems admitted that there were significant changes, but maybe he did. But then the disagreement is, are these significant changes which, came at a cost, not at a cost, came at a great effort to the US, are they enough, right? It's like when you have an argument with your spouse, it's like, I didn't mean it. Well, I don't care, I'm still hurt, right? So it's like, we made an effort, but is that enough? Is that still, in line with the European standards? So that's one question. With the follow-up question that Sebastião alluded to is that the EDPB can comment on this. When they do, the European Commission doesn't have to accept it. But if, at least historically, if there are things that the EDPB says that are a problem, and there is a likelihood that they can be fixed on the US side, so they're not an impossibility, then it is likely that the European Commission will accept them because it's doable, right? And so one query, right? There are a lot. If you read the Neub, write-up of the executive order, you will see that there are a lot of different arguments there. Some of them are smaller and some of them are fundamental, right? And I think that some of the smaller arguments, for example, Max Schrems said, what's the deal with government officials? Like, well, how is this related? There are criminal enforcement pieces in there that are not national security, right? They're like specific things. Those might be fixable, right? The definitions, like tightening things up, etc. But the fundamental concept, which he said, this is not European proportionate because bulk surveillance is not overall prohibited. Well, I mean, that's a bigger problem, right? And that's a more fundamental problem because European countries have bulk surveillance too, right? With limitations, etc. But they do, and it's just not subject to GDPR, and therefore, it's not in scope, but okay, that's life. So that's one area, is that in the surveillance piece, are there pieces that can be improved in order to make the situation better or not, number one? And then number two is the commercial principles, and that I think I'll go in detail later, but those, I think it's kind of clear that there is room for change there, because that doesn't really require much heavy lifting on the US side either. And there are arguments why this should be done. Namely, it is arguably, there are things where it is not close to GDPR. And there are also places where it is less strict than the one, new US privacy laws, and two, US privacy bills, and three, FTC decisions. And therefore, right, and I'll talk about why that's important, but that's one place where we might have wiggle room. And so that's kind of the setting the stage. And I think the rest of it, instead of taking a lot of time, I think we can dig into the questions later.
Thank you very much, Odia, for your incredible.
How's my Portuguese? Was that excellent Portuguese? No? Okay.
Oh, for not best Portuguese I've heard, and I'm a native, so. No, but seriously, thank you very much for your input, and thank you very much for laying the seeds for many of the questions that we have in store, which we unfortunately will have to be selective about. But I would like to start with probably one of the points that mostly concerns controllers and processors, which is that much emphasis ever since the Shrems II decision has been put on the mechanisms for international data transfers contained within the GDPR. So we're talking about, as we all know, what the standard contractual clauses, administrative agreements, and all of these emphasize the TIAs, which has been oftentimes a blocking point and considered necessary for the transfer of data to the US. So with the executive order and the draft adequacy decision and what's oncoming, I would like to know your thoughts on what this decision represents for all processors and controllers, and if you would have some general advice for them, what would it be, assuming that some of them are here in the audience, which most likely they are. So I'll give the word to both of you, whoever believes it's.
Do you want me to start? I can start. So with the focus on the TIAs and generally. So, the joke is, or not a joke, is that in English, or at least American English, TIA is also an acronym for a mini stroke. And that may or may not be a coincidence. So this is a very difficult, thankless process for companies. It is also a process where, and I think, everybody recognizes that one of the intended or unintended consequences of this is that there is a disproportionate burden carried by SMEs on this process. And also for a variety of reasons. Number one, because this kind of, lack of and there was talk about this lack of kind of one place where companies can go to for some sort of standard analysis that they can rely to, rather than, it's like basically, I don't know, those of you that are in law firms or whatever, it's like basically, you know, rewriting like your template 50,000 times over instead of having something that you can rely on, right? So that's one thing that's unfortunate. The other is, even one is difficult and expensive, but two, it is impossible. So those of you that have followed, there is an organization called Privacy Company in the Netherlands. They did a number of TIAs and DPIAs for the Netherlands government on big service providers like Microsoft and Zoom, etc. If you read the preamble, the summary of this, they basically said that it took them months, I think in some cases like 9 or 10 months, back and forth with the provider, highlighting the high level, doing the analysis, trying to figure out the actual transfers, figuring out what the high level risks are, going back to the company, having the company change its actual features in order to accommodate so that they can reach a result of, you know, acceptable risk. That part is not, you know, something that you can do yourself, because you don't have the bargaining power. There's no way that you could get that deal, right? And so that's really difficult. That's why this is hard and depressing. What is the silver lining here? So number one, if and when or in whatever format the adequacy decision passes, then there's still people out there, probably they all live in Germany, no, but maybe most of them, that are still not going to trust Privacy Shield, the DPF. They didn't trust it before. And they may say, you know what, you still need a TIA because I need to understand. Now that part is actually, and by the way, there are those, including regulators, that are basically saying in the Denmark issued some of their decisions as well as their cloud report. They basically said, you know what, like the TIA, you need an analysis of your transfers anyway, even if it's not because of an Article 46, 45, 46 transfer issue. If you have a processing and the processing entails a transfer, in order for you to meet with Article 24, 25, and 28, in order for you to meet with your obligations as a controller, you need to know the transfer. So you need to know the transfer anyway, and that's the non-law part of the TIA. And then the surveillance part of the TIA, you can say, hey, adequacy decision, I'm not worried about the NSA and my cookies, great. So what's the takeaway here? The takeaway here is, one, notwithstanding an adequacy decision, you still need to do an analysis of your transfer. You need to know the transfer. You need to know your processors. You need to make sure your processors are actually processors, and that's a whole different discussion. This is, again, very difficult because the processors have processors that have processors. And I once looked, and somebody, the sub processor was processing in Iran. I'm like, well, how are you doing this? This is not good, right? So you need to know. You need to have, you need to know, and you need to have the right controls, and you need to have the SECs or not if you're relying on the DPF, but you need to know the transfers. You also need to go back to basics, which is, I think this discussion of, you know, Shrems has at least, and some of the regulators are saying this either out loud or not out loud, has basically clouded over the more substantial and substantive GDPR issues that are somewhat more important than the NSA and the cookies, right? You need to look at your transfer and your data collection generally and say, do I need to be collecting this information at all? Like, do I need it? If I need it, can I pseudonymize it? Can I anonymize it? Can I aggregate it? Can I not share it? Do I need to share it? All of that stuff are things that you needed to do and should have been doing regardless of Shrems, and you need to continue doing that. You also, with the heightened requirement for documentation and accountability, you need to document that, and basically meet with and that way basically minimize the risk. Now, can you avoid the risk? There is a whole discussion about risk-based, right? You say risk-based, to NOIB, you say risk-based to DPAs in Europe, everybody gets like breaks out in hives, right? Because no, there's no risk-based with respect to transfers. I've had these conversations with people a lot. And let's say yes, right? It's like for, you know, in litigation, in the preliminary stages of proceedings, you have, you know, let's assume for the purpose of the argument that all of the facts stipulated will be found out to be true. Is there a case, right? So let's stipulate for the sake of argument that there is no risk based in transfer, right? Let's assume. So, but you can't do it, right? And in that situation, you are left with either trying to minimize the risk and still have it be a violation, albeit a smaller one, right? Or saying, you know what, I don't care. And in those situations, it is always better to minimize the risk. And in that situation, you, even if it is technically a violation of the law, when the regulator comes knocking and investigating, or somebody tells on you, etc., because you have lowered the risk, even though you are still in violation, because you know what, cry and pray, can't do it, you will have minimized it to the point where your penalty is lower, or you won't get a fine, or at least you will have improved the situation.
I can follow up on that because it was a long intervention with a lot of, you know, content, but I want to focus on a narrow part of Odia's intervention. I don't know if we lost her actually.
Sorry, I'm here. My camera just hates me. Maybe it's, yeah, there we go.
Okay, good. Now I wanted to follow up on the fact that even though there is an adequacy decision, you still need an assessment, a risk assessment. Yeah, a generic risk assessment is always required. No, it's the basis of the accountability principle, and you know, you also need it to engage processes, etc. Of course, it's not the same as a transfer impact assessment as per the DPP recommendations that focus on government access to data, minimizing the risks of that happening, etc. Is just a different type of risk assessment, but sure, you still need to do it. When it comes to the U.S. adequacy decision specifically, of course, some U.S. officials have been saying, now we have introduced these changes via the executive order and the DOJ regulations. These safeguards apply to EU citizens' data, regardless of the mechanism you choose to transfer the data. So it also applies to data that is transferred on the basis of SECs, on the basis of BCRs. So this means that the data exporters in the EU, and they have been encouraging this, should include these new US legal developments in their transfer impact assessments in a positive light, saying, okay, there are changes in US law. It's less likely that the access is disproportionate. So there is a risk reduction, and let's continue business as usual. The Commission, although, has warned that until the intelligence agencies in the US side adopt the reforms that have been mandated in the executive order, and until the Data Protection Review Court is actually operational and running, the executive order and the DOJ regulations have actually little impact on the risk assessments that are mandated under the DPP recommendation. So it is not because there is an executive order in place that it is actually completely effective. So there are still steps that need to be taken by the US intelligence community, and the redress mechanisms are still not operational. So this means that if you're doing a TIA for the US and you're thinking about, you know, assessing it more lightly because there is the executive order in place, just think again, because it is clearly not in full force yet. It may be, if you rely on the SECs, for instance, after the executive order is fully implemented and there is the adequacy decision, it's way more likely that the assessment will be a positive one. But as of the moment, you still need to be very cautious about how you consider these developments in TIA.
Thank you, Sebastião. And thank you, Odia. And this comes to mind like very briefly, and this is like very much tied to it. So feel free to answer briefly if you believe it's necessary. But one thing that EU companies have often struggled about when adapting to this framework is that they have little to no really viable alternatives, well, other than, well, like we were saying, AWS or Office 365. And from a business perspective, they are practically, I've had, for example, supervisors of mine in places I've worked on saying that they pretty much have to incur on the risk regardless. And on this note, and let's consider that the final decision is not expected before spring, but even assuming that it passes and that it somehow gets repealed, do you believe that controllers are very much incurring on risks or putting themselves in a vulnerable position if they already start prepping their business models for, well, the new decision?
Yeah, yes. I mean, I think the answer is yes, right? And then because we know that it's not legal, as Noib likes to say, right? Illegal, Google Analytics, right? We know that there's a decision, and we know what the decision says. So is there a risk? Yes. Are companies taking it? A lot of them think yes. Are some companies not taking it? Also, yes. So I mentioned in the discussion before, in the green room, right? I just did a webinar with the DPA from Norway, and he said that there are a lot of situations, and they're hearing from Norwegian companies. I am sure this is the case, and at least in Germany and other cases, where there are companies, and like specifically in Norway, like, you know, public service. And we've seen it in Sweden, and also there a lot of the Nordic countries have specific like public sector laws that have a transfer limitation, which is even stricter than normal. And the projects are stopping. They actually started projects and they are stopping projects because of the risk. So one, are companies incurring risk? Yes. Two, are they avoiding risk at potential detriment to business or society? So for example, he said that there is a medical health research projects that are using US providers that are put on hold because of this. So that's one kind of consequence. Now, what do you do about it? What can you actually do about it? What you can do about it is what I said before, which is do the best that you can. It's like you guys are in law school, right? So in the law school, right, if you don't know the answer, you don't know the full answer, right? You still like write, and you write as full an answer as you can, right? And do what you can. So here it's the same thing. If you cannot reduce the risk completely, then you reduce whatever part of the risk you can, right? So I'll give an example, and I like how my camera is stuck on a very pensive kind of, position here, but I'm thinking deeply about this answer. So one example is, let's say, and this is a true story, right? Let's say you have a service, you are relying on a third country provider, I don't know, in India, in the Philippines, in wherever, like Vietnam, Thailand, Ukraine, I don't know, third country. And in that situation, you need the service. You need it from a price perspective. You don't have a viable EU or, adequate country alternative, right? And so what you do is you then try to do your best to mitigate the risk. So the provider that is looking at your data, you are trying to use an EU-based storage. You are trying to give this provider only read access of the information. They can't download it. They can't screenshot it. They can't share it with anybody else. So that the only exposure that you have is the person is looking at it with their eyeballs on the screen, and behind them maybe comes a police officer or somebody from the security of whatever this country, and they look at it, right? Like they come into your office and they look at it. Is that still a transfer? Yes. Is that is that therefore you now have incurred a risk? Yes. Have you reduced the risk to the point where your exposure vis-a-vis potential enforcement has been lowered? Also, yes. So my answer here is there a risk? Yes. Are companies tolerating it? Some of them are not. And those that do, I would suggest, despite the fact that, you know, there is no risk-based, take the risk and try to minimize it as much as possible. It's still going to be a violation, but it's going to be less severe consequence for the violation.
It also depends on which EU country you're based on, right? Because there are some DPAs that take very restrictive stances, no risk-based approach, what some call the absolutist approach. Like you have to eliminate the possibility that a foreign authority will access the data instead of reducing the likelihood, right? Or reducing the chances. So if you think of cases like the Google Analytics enforcement in France or in Italy or in Austria that focus on the elimination of the risk, then you know you're in trouble. We also have enforcement action in Portugal post Shrems II with the Cloudflare case, etc. That points to a very low tolerance to risk by the local DPA. Of course, the most risk-free option is to only use EU-based providers, in particular ones that are not controlled by foreign entities, according to the criteria that are set in the study by the Dutch Ministry of Justice. Because the other issue that DPAs and courts focus on is not only on whether there was a transfer and whether the data that was transferred is subject to access abroad, but also whether if data that is stored in the EU, because of extraterritorial law enforcement requirements, think of the US Cloud Act, is still subject to request by US authorities, right? So you also need to check, if you are completely risk averse, whether the EU vendors that you're relying on in their governance structure are completely free from influence and control by US or other third country companies. There are some initiatives, of course, that are being developed by US-based cloud companies to help their customers comply with Shrems II and the EDPB recommendations. We've seen the Microsoft EU Data Boundary project that is being rolled out this year. We've also seen Amazon key private servers, so they give the encryption keys to their customer, and there's no possibility that they can then access the data. Is that an adequate supplemental measure? The fact is that we haven't seen, of course, stances by DPAs and courts on these specific use cases, so it's hard to tell. And it's anyone's guess what would be sufficient to enable US transfers to the US that rely on the STCs to cloud-based providers. Probably there's very little you can do without being subject to some degree of risk.
And I want to add one more thing, which is sort of a practical point that I also heard from, both the DPA in Norway, as well as I think in Denmark too. So there is this small opening in the EDPB guidelines that say that you need to show, even though the US law is a problem, if you are able to show that it is not applicable to your transfer, then you're okay. That is still a viable course of action, but there is a non-trivial burden of proof to be able to demonstrate it. And so far, we haven't really seen it done well enough. So in the Google Analytics cases, right? In the DSB case, I think this was DSB. It was either DSB or the European Parliament or both. Google said, we have never gotten a national security letter with respect to analytics, and they had some sort of evidence like that. Now, that was not deemed convincing or adequate enough in that case. But if you are really able to show, and the EDPB guidelines say you can, ask your provider for their industry experience. So the industry experience of just Google may not be enough. But if you, let's say, are able to, with respect to analytics, you're going to say, oh, well, Google Analytics never got a response, and Potato Analytics never got a request, and Carrot Analytics never got a request, right? And so basically we see that the NSA is not in the business of asking, sending national security letters with respect to analytics, and you show it in the market, that may be enough to say, okay, you know what? It doesn't apply to this type of transfer.
Not that Google can disclose, of course, the fact that it receives such requests. That's all the other issue, of course. And in the DPP guidance, it opens that door, and I agree that there. But it also says it's the last resort, the last element that you need to consider, because first it's the laws and practices of public authorities in third countries, and only if the information is not reliable or you cannot do the assessment on that basis alone, then you can consider industry experience, receiving requests, handling them, etc. So it's like the last resort to go to, right?
Well, I mean, as I said, right, Keneal actually did have an opinion that said, skip the analysis, just skip it. It's not going to help. Go do a technical measure, right?
And taking the opportunity now and jumping to, well, sort of the other side of the ocean, I would like to specifically look at the US framework and ask, what can both of you tell us about the most recent changes that have been made in light of the executive order, and what they mean for the future, regardless of the fate of the adequacy decision? What are, well, positive consequences that you foresee, and, well, inherent problems that you might be foreseeing as well?
Can I take it first, Odia, this time? I'm more optimistic this time around, I have to say, because I think that indeed there is some substance to the changes that were introduced with the executive order and the DOJ regulations. Of course, only the judges in Luxembourg will know in the end, but I'm more optimistic this time. There are some interesting takes by DPAs in Germany, and the DPS himself expressed that they are more optimistic this time around. They have, commended some of the improvements made. We also see that this effort, these very long negotiations that happened between the EU and the US on the enactment of these safeguards, has influenced another parallel process, which was the OECD principles on government access to data that were passed the day after the draft adequacy decision actually came out. And I'm not sure whether, the US being part of it would have green-lighted, let's say, those principles, which of course are non-binding, but principles that were commonly agreed by like-minded democracies on whether governments can access data for law enforcement and other purposes, if these negotiations hadn't happened. So I believe this is also a positive consequence, that it started like a proper consensus around, democracies all over the world on what is proportionate, what is necessary to attain these goals. So that's a very positive development in my view. The other thing that the executive order creates is kind of an awkward conversation when we flip the eyes to EU member state practices. And of course, Odia also referred to it in the initial intervention, which is the concept of qualifying states under the executive order. So what the executive order says is that individuals can only use the redress mechanisms in the executive order if they come from a so-called qualifying state. And what is this qualifying state? It's either a country or an organization that the Attorney General of the US decides has in its own legal order equivalent protections as the US has against surveillance practices in their own legal order and similar redress mechanisms, right? So this will be decided on a country by country or group of countries basis. Let's say the US can also say the EU gives adequate protection to US citizens when it comes to government access to data. But what the Attorney General can also do is look at individual EU countries and see if their compliance, their surveillance practices actually comply with the high standards that are enacted in the executive order, and say, actually, let's imagine Hungary or Portugal don't comply with these standards that the EU itself is requiring us to comply with. So we're not going to let citizens from Portugal or from Hungary rely on these redress mechanisms, because there's actually no redress in Portugal, no redress in Hungary. The problem here is, of course, and Odia referred to it, the EU has no competence to tell its member states what they can and cannot do when it comes to national security practices. So access to data for national security, and it's a limitation of the treaties of the European Union. So it seems that the EU, to some extent, is requesting the US to give more privacy protections when it comes to government access to data than it can actually impose on its own member states. So it would indeed, if the Attorney General were to be so bold as to say, hey, actually one of these countries does not qualify, it would initiate a very awkward conversation in the EU. So the concept of qualifying states, I think, will push EU member states to look into their own practices, hopefully, and actually reform their own surveillance laws to an extent that would comply with the Charter and the fundamental rights and human rights standards that we have in Europe, because we know that some of them do not, as it was highlighted by various fundamental rights agency reports from 2015 and 2017. So yeah, these are the two big consequences I see from the approval of the executive order as it is.
So I think, what are the consequences of it as such? I think that, I mean, the US really has done a lot to get itself closer to the point, to the standard that was requested or, imposed. That depends how you're going to look at it, in Europe, right? So like, your boss, right, Jules Polonetsky, had a post and it's like, drop it, Max, you've won, right? Okay, so it's like, it's there is a big step there, right? I mean, also, this concept of bringing, sunlight is the best medicine kind of thing, and like bringing this to light, and I think having this also inform potentially the decisions with respect to the amendment of FISA, which is up for amendment and all of that. I think that also is a good idea, right? I mean, as the things that are happening, in the news, and, I grew up in Israel, so I'm really well aware of national security issues and how they impact your life. This is a very complicated subject, and it's really important, but we all know that there are, and we've seen, right, where it's easy to kind of, slide into, excessive monitoring, et cetera, right? So I think that's really important. And then the other piece that is important, I think, is potentially going to be with respect to the principles. And I don't know, do you want, Diogo, for me to jump to the principles a little bit and talk about them, or do you want to wait for a question on that?
No, by all means.
So I think the principles are interesting. So the principles are like the non-NSA ate my cookies piece, right? It's the commercial piece. It is the standard to which companies need to abide by, which they need to abide and self-certify that they are in line. I think that here's why this is interesting. One, it's interesting because this is actually something that you can do. This is something that companies have control over, right? It's like in the, 12-step programs, right? Like, give me the serenity to accept, the things that I can't change, and the courage to change the things I can, okay? So the commercial principles are the things I can. And all companies, US-based companies, can, abide by these and certify to them. There's already been discussion on, the FTC, which is the enforcement authority assigned to enforce this, looking at Privacy Shield certification as some sort of evidence of compliance with a privacy framework of sorts, right? It is a framework that you can kind of abide by, and FTC has looked at it. So one, it's important because it's something that you can do. Interestingly, with respect to the principles, if you run a black line, and Coben from the IAPP did, you will see that there is virtually no change from the privacy shield principles to the DPF principles. Really, somebody went, Control H and changed privacy shield with DPF, and that's pretty much it. That is a problem because, and Max Shrems already said that that's like already going to be in their lawsuit, right? And they've spoken about it before. Right? The argument before was that Privacy Shield wasn't even in line with the directive, and Privacy Shield wasn't in line with the GDPR. And therefore, if you haven't changed anything, how are you in line with GDPR now? Right? So that is an issue, and that is probably, and I maybe am less of a European trend predictor, but I think that is one place where probably there will be EDPB comments. And there is a higher likelihood that those will get accepted by the European Commission, because that is something that actually where change can actually be impacted. You don't need an executive order. You don't need like a lot of political capital, especially because, and that's the next part that I want to say, especially because the climate in the US has changed dramatically in the past few years since Privacy Shield was passed. So the second takeaway here is that even though the principles have not really changed, the text of them hasn't changed, and that will probably feed further change pursuant to European comments. The text itself doesn't mean today what it meant 5 years ago. And that piece, there is actually a whole piece, that article that I wrote about it on LinkedIn that you can find that lists why. But basically, the FTC today is not the FTC 5 years ago. Privacy laws today are not what they were 5 years ago. Expectation of privacy by people in the US isn't what it was 5 years ago. And so when you look at these principles, data minimization, purpose specification, purpose limitation, retention limitation, agreements with processors, all of these things that have very profound meanings under GDPR, and 5 years ago weren't a big deal. Now we have FTC enforcement on data minimization. We have a notice of proposed rulemaking by the FTC on commercial surveillance. We have the CPRA in California. We have CPA in Colorado. All of these things now mean things. And so when the FTC has already enforced about this in the US, why wouldn't the FTC enforce about this? And there's actually a statement in the packet where the FTC is saying they will enforce more strictly, partly because, one, that's what they're doing now anyway, but two, part of the arguments in the Privacy Shield review, some of the comments by the EBPB were, the FTC is like a rubber stamp, like the DOC is a rubber stamp, nothing's happening, you submit a request, it's approved. And the FTC is like, no, we are going to take this seriously. We're going to look at it. And actually, there was a decision by the FTC, Cafe Press, that wasn't transfer specific. It was pursuant to a breach. It talked about data minimization, but it also took to issue a failure to comply with Privacy Shield as a violation of the FTC Act. So we already see that there is already substantive enforcement by the FTC. So I think that's really an important significance.
Don't know if you have any additional comments, Sebastião, before we jump to the next topic.
No, not really. I'm curious to hear the next question and also to hear from the audience.
Yes, because the next question, in order to allow for the audience to place their questions, is going to be the final closed question that we have for the panel. And it's very interesting in the sense that I'm looking at the adoption and the very maintenance of the adequacy decision of the data protection framework. And considering what Odia said, and the notion that what were previous concepts of privacy and data protection and how radically they have changed over the past couple of years, and well, given the fact that we have Noib already announcing that, yes, we are probably going to sue as soon as this comes out. I would like to know what are your expectations on whether this is going to be a continuous cycle of breaking and rebuilding agreements, or whether do you think that this final decision that comes out of the DPF shall finally serve as a building block for broader multilateral collaboration? Because I think this is an interesting topic to close these main questions. So feel free to debate on it.
Well, I really hope there would be, a final chapter to the saga. I think it would more likely be such final chapter if the US also looked into its surveillance laws, such as FISA 702, which is up for renewal this year, right? There's a public consultation going on whether, they will keep FISA 702 as it is, or if they will reform it, or they will repeal it, etc. Because this has been, some of the main concerns of the Court of Justice have been around FISA 702, Executive Order 12333, the biggest concerns have been expressed there. So if there could be a reform of that law that was sort of in line with the requirements that were enacted now in the executive order, I think this would have higher chances to constitute a long-term solution to the conundrum. But then again, I already mentioned how important these sort of concessions were in the executive order to build a consensus in several countries about what is necessary and proportionate at the OECD level. So I'm optimistic that this will bring change to the conversation and actually a more stable arrangement. At least at FPF, we hope it does. But the final word is for the Court of Justice. It could be in 2, 3, 4, 5 years. We don't know when it's going to reach it, but we'll keep following the next episodes of this.
I can't predict. I mean, Shrems has already said, what was his quote in the IEPP conference was like, I'm emotionally tired of, fighting about the transfers, but oh, well, I'm going to do it anyway. So we already know that there's going to be a challenge. And so we'll see how it goes. But I think the only thing that I can say is that, number one, the more I think it is, everybody is conceding that this is progress, especially with respect to the surveillance part. So hopefully that will either be enough, or the EDPB comments will be such that can be adopted to the point where a challenge won't be accepted, right? And then the other piece is the commercial piece, and the commercial piece, I mean, there is going to be a challenge, and it's hard to say why there wouldn't be a challenge, because there was already a challenge and there was no change. So unlike the surveillance piece, right, where there was a significant change, the commercial piece, there were already challenges and nothing changed. So those need to change, but those at least are not kind of ride or die kind of thing. They can be changed, and I think it would be a good, like, higher standard of compliance for companies. So I think I don't know, but I think that even if it gets accepted, I think that in itself does have at least some impact on companies, even if companies are not relying on it as an adequacy decision, because it's precarious and because there's a pending decision. I think that even when you do your TIA and you say, okay, well, there is an adequacy decision, blah, blah. I mean, I think that does carry weight in the kind of extreme, like, go, no go-ness of the analysis right now, which is, oh, lock out the NSA. This is, this is impossible.
Thank you, both of you, for your very rich clarifications on the topics. And that being said, in order to allow the audience to properly engage with our speakers, I am happy to open to a round of questions from the audience. So whoever feels free can comment on the chat or can raise their hands to speak. Feel free. See. You can also feel free to unmute and just state your question if it's simpler for you.
I think they're concerned because Zoom is in the US and now they're transferring their personal data. So
I can ask a question if you can hear me.
Yes, by all means.
Thank you for excellent presentations and very interesting discussion. Maybe just very briefly a point. I think you both mentioned lack of certainty for SMEs and this kind, of situation where businesses have to constantly change something and they are not really sure whether what they are implementing will be future-proof, whether in like 2-3 years there won't be another mechanism. So the question is whether maybe Commission shouldn't push the US counterpart more and try to come with something even more meaningful, because we are at this very strange situation where the draft adequacy finding, is not yet there, but we already know that there will be a legal challenge, and basically we already know that the outcome might be not positive. So basically, do you have any position on that? And I think I heard the second question. I think I heard basically the assessment of the framework by Odia, but Sebastião, what is your opinion? Do you think that the mechanism will survive the challenge in the court or not? Many thanks.
Maybe I'll start with the second question because it was addressed to me. I mentioned several times, I think, Michal, but thank you for the question, that I'm indeed more optimistic this time around because of the more palatable solutions that were presented in the executive order. Of course, pending actual implementation by the intelligence agencies in the US of these reforms, pending the enactment of the Data Protection Review Court, etc. I'm more optimistic this time around. I think DPAs are too, and this is what matters in the end. Of course, it's not ideal in a world that there are such significant restrictions to data transfers under the GDPR for EU companies to only be able to confidently transfer data to 11 or 12 countries that were already deemed adequate by the Commission. It's not the ideal world. Many people, not that they call for, the Commission issuing more decisions faster, etc., and not careful enough. At least companies call for, at least give us a list of countries which are not adequate, like that we shouldn't transfer data at all. That would already be helpful. But of course, we know how politically sensitive that would be. That's why, of course, the Commission or DPAs don't want to do it. I don't see that happening anytime soon. And as per the leverage that I think the Commission has with regards to the US, at least from what I've heard from the negotiations, which lasted way longer than the Privacy Shield negotiations. If you remember, the Privacy Shield was annulled in October 2015, and in March 2016 there was already a draft adequacy decision on the basis of the Privacy Shield, and this time around it took more than 2 years, 2 years and 3 months or 4 months to come up with a replacement or a tentative replacement. So it means that that they really put an effort into. They really don't want to go through the embarrassment of having it annulled a third time. And I believe they pushed as much as they could. If there is still leverage to continue pushing, especially after the DPB opinion, which I'm sure will raise some reservations, maybe. But I do commend the Commission for their efforts, which resulted in what I believe are stronger safeguards for EU citizens when their data is transferred abroad. So, yeah, that's my opinion.
I don't remember what the first question was. What was the first question?
It was about SMEs and, you know, we still lack legal certainty and, you know, the cost for SMEs of another mechanism that is probably not future-proof.
Yeah, no, I think that's a problem, and I think that's why hopefully it sticks, and hopefully it sticks for a long enough time, you know. And the other thing that I can think of is that, you know, if there is this decision, and I don't know, I'm speculating, but I think if there is a decision, even if the decision is being challenged, I think that, you know, there would be less of an appetite for severe punishments, you know, in this regard. And so far, what we've seen, by the way, and we'll see, of course, there's the big meta case, which, you know, we'll see when the final decision, it just went to just started the Article 65 procedure. So we'll see, right? That is going to be a big deal, right? But I think until now, what we've seen, at least we haven't seen like severe fines in this realm, even though arguably, you know, an injunction is worse than a fine in this situation, because you can't do what you need to do. So I agree. I mean, that's why cry and pray, right? Somebody say it out loud in Portuguese so I can hear it. But yeah, that's what I think. I think it's really frustrating.
Chorar e rezar. That's how you say it.
And we have a question from the audience in text from André Cunha, and he's asking, considering Brazil, Canada, USA, and the EU, would it be possible to have a legal paper committing these big democratic spaces on a practical data market platform? I don't know if it's directed to anyone in specific, André, if not.
I mean, this part is the non-politically correct part, which, you know, there are those that say that there are political aspects relating to these adequacy decisions, right? I mean, you know, the US obviously is, you know, the NSA is a big problem, but the counterparts in other countries, right? England has a very similar apparatus, yes. UK law is currently very similar to EU, but if the NSA ate my cookies is the big problem, because that was the big problem, right? US law is not identical. We don't have a federal privacy law, et cetera. But all of that was sort of, you know, kind of slid through in the reviews, but the NSA part was bad. So if that was the bad part, then why is England okay, right? And so the discussion here, on, you know, Canada and the UK and Five Eyes and all that stuff is a discussion that I don't know where it's going to end. And the other piece that I wanted to add, Sebastião talked about the 11, you know, adequates. All of those countries are currently undergoing review of their adequacy status. And so that's also going to be an interesting situation, because some of these countries, I mean, I was just, as I said, did a Privacy Day event in Israel. We were talking about the Israeli adequacy. Israel got its adequacy in 2011. A bunch of the other countries also, except for, you know, South Korea, Japan, the new, you know, adequacy decisions that had a lot of built-in mechanisms and also measured against GDPR. The other ones got adequacy opposite the data protection directive. And like, you know, 12 years ago, 13 years ago, now who knows what, you know, where those stand. And that we'll find out, I think, this year, what's going to happen with them.
Well, I run the risk of taking the question too literally, but I'm going to try anyway. US, Canada, EU, and Brazil. Those were the jurisdictions included, right? So if you look at the current adequacy decision, you have an adequacy decision for Canada, only for commercial enterprises. So there is free flow of data between EU and those enterprises in Canada. but there is no adequacy decision with regards to the US nor with Brazil. There may be a very soon adequacy decision with the US because of the decision we've been discussing today. With regards to Brazil, they have a modern data protection law that is modeled very close to the GDPR, which is the LGPD. So it is quite likely that the EU will, at one point or another, launch negotiations with the Brazilian authorities to enact an adequacy decision with regards to Brazil. I know that the DG Comp unit at the European Commission, who is handling data flows, is looking into Latin American countries to enact new adequacy decisions. And I believe this would include Brazil because the law that they have now is the closest that there is in the American continent to the GDPR. So if there were adequacy decisions with regards to all of these countries by the European Commission, in theory, we could look into a trade partnership between the 4 countries, including all of them, that would include the free flow of personal data among them, and in principle, there wouldn't be an issue. But as you know, there is not 2 adequacy decisions there that are missing, and so such so-called platform could not exist as the law currently stands. So.
And do we have any additional questions from the audience? Anyone interested in placing another question? I saw one earlier that was in the meantime deleted, but I can appropriate it for myself because I found it interesting. And it was for Sebastião, which is considering what Odia said about the idea of it being very important for controllers to at least demonstrate their efforts in at least attempting to mitigate or at least taking this safe approach. Would you believe that the Portuguese local authority would be sympathetic towards this sort of approach in the event of a prospective complaint or any similar approach?
Yeah, I was thinking about it because Odia said that DPAs in general have not fined entities for a breach of data protection, like international transfer rules post Shrems II. If I can think of one exception, it is precisely the Portuguese DPA, because both in the case of the census and more recently, I think there was another case, the DPA actually imposed sanctions for a breach of a number of GDPR provisions, including the data transfer provision. Of course, it was against 2 public bodies and not companies. So basically, it's also a position of force by the DPA saying, so you didn't want the GDPR to apply to public authorities, there you go, I'm imposing sanctions against you. So maybe the DPA looks, with softer eyes towards companies who try to comply with the rules, but definitely not against public bodies. And there may be a number of reasons for that. I suspect some of them, but I cannot be sure.
But also, wasn't it true that the Cloudflare case, I don't know which the other case you were mentioning, but wasn't it like there was one case where I think, weren't there like biometrics and profiling and like something sensitive, like sensitive information involved?
That was the EdTech case. And so this proctoring software that was used by a Portuguese university, but that was the compliance order, so it wasn't an administrative fine against the university. So that's an exception. The Cloudflare case is the census case. So because it was the National Statistics Institute that relied on the Cloudflare technology to host the census that it carried out. So it's basically the same case.
Yeah, but I mean, arguably in those situations, like I mentioned with Norway, where they're stopping projects, I mean, in those situations, I think wouldn't an injunction be even worse than a fine, right? Because you can't do it. 1, you're stuck. 2, you've got to redo the project. So then you're expending funds to redo everything. So that's, a financial burden anyway.
And that's what happened in the Cloudflare case, because when it got out that this was happening, there was an order from the Portuguese DPA for the National Statistics Institute to stop relying on the packets that were delivered by Cloudflare. So basically, they ordered them to stop relying on Cloudflare as the processor. So that happened too.
Thank you. And I believe that in case we do not have any additional questions, speak now or be silent for the rest of this webinar. And given that, I believe that we have reached the satisfactory point, and given the fact that it is almost 8 p.m. for the Portuguese folk, I believe that we can close the session unless there is one final question anyone wants to place. If not, I would like to thank everyone for being present. Special thanks, of course, to Odia and Sebastião for the phenomenal presentation and for the phenomenal input. I'm very, very grateful for you having accepted the invitation. And I hope we can keep in touch and collaborate soon again. And thank you everyone for attending.
Thank you very much for the invitation, and you know, happy Valentine's.
Thank you very much.
Thank you very much. Bye-bye.
Bye.